तो आप लोगों का स्वागत है हमारे चैनल टेक लॉज पे। तो आज हम लोग बात करेंगे, ये हमारी पहली वीडियो है जो फंडामेंटल राइट के बारे में है। सो इन दिस वीडियो सीरीज वी आर गोइंग टू कवर द फंडामेंटल राइट। तो फर्स्ट ऑफ ऑल हम लोग बात करेंगे फंडामेंटल राइट के बारे में। फंडामेंटल राइट is like in part third of the Constitution of India, and today we are going to discuss about the Article 12. So Article 12 की जो definition है, let's see the definition first of all. In this part, unless the context otherwise required, the state include the government and parliament of India and the government and the legislature of each of the state and all local or other authorities within the territory of India or under the control of government of India. Okay, this is the definition given under the Constitution of India. So आपको डायरेक्ट में ये definition मिल जाएगी. So now हम लोग इस definition को थोड़ा सा bifurcate कर देते हैं. Let's see. So according to the state definition, include the following: government and parliament of India, that is executive and legislative organ of the union government. Okay. So first thing क्या है कि government of India की जो पार्लियामेंट ऑफ इंडिया है उसकी जो एग्जीक्यूटिव बॉडी है और जो लेजिस्लेटिव बॉडी है यूनियन गवर्नमेंट की, दैट इज द फर्स्ट ऑर्गन ऑफ द स्टेट. सेकंड, गवर्नमेंट ऑफ लेजिस्लेचर ऑफ स्टेट, दैट इज एग्जीक्यूटिव एंड लेजिस्लेटिव ऑर्गन ऑफ द स्टेट गवर्नमेंट. सेकंड, गवर्नमेंट जो है आपकी स्टेट गवर्नमेंट की जो लेजिस्लेटिव बॉडी है और जो एग्जीक्यूटिव बॉडी है वो स्टेट गवर्नमेंट. ओके, दैट इज द सेकंड बॉडी. All local authorities, that is municipal, panchayat, district board, improvement trust, etc. All other authority, that is the statutory of or non-statutory authorities like LIC, ONGC, SAIL, etc. Okay, so all these are comes under the state government. अब हम लोग देख लेते हैं कि state definition also include, according to the Supreme Court of India, even a private body or an agency working as an instrument of the state falls within the meaning of the state under Article 12. Okay, this is the definition, like interpretation given by the Supreme Court of India. So how to decide the state? Deep and pervasive control. So हम लोग देखेंगे कि उसका जो कंट्रोल है बॉडी का वो कितना कंट्रोल है. मोनोपोली. Okay, and function of the public importance and agency and the instrumentality of the government. So this is the thing, like how we are going to decide the state. So there is a 4 case law which we are going to discuss in this video. Ajay Hasia versus Kalid Musid. So regional engineering college run by the state, that is the first case. PK Ramcharan Iyer versus Union of India, ICAR is a state, that is the second case. And Tekraj versus Union of India, Institution of the Constitutional and Parliamentary Studies, a non-state. Fourth, RD Shetty versus Airport Authority of India. Supreme Court held the first time cooperation can be said to be an instrumentality of the state. So let's see. So ratio descendi of the case of Ajay Hasia versus Musid. So the Supreme Court of India in this ruling deliver a significant interpretation of the Article 12 of the Constitution, which has had profound implication of the definition of the state. The court rule in this favor of the petitioner established the principle that the formal statute of an institution, where registered as a society or not, is less consequential than its functional character. So इसमें सुप्रीम कोर्ट ने बोला कि जो प्रिंसिपल जो फॉर्मल स्टैचू है, जो इंस्टीट्यूशन है, वो अगर रजिस्टर्ड एज ए सोसाइटी है, इट डजंट मैटर, इज लेस कंसिक्वेंशियल इस फंक्शनल कैरेक्टर की. उसकी फंक्शनैलिटी कैसी है, उसका फंक्शनल कैरेक्टर कैसा है, हाउ ही इज गोइंग टू बी फंक्शन. सो दिस इज द फर्स्ट थिंग विच इज सुप्रीम कोर्ट like give the ruling. In delivering this its verdict, the court held that if a body is functionally, structurally and financially acting as an instrumentality or agency of the government, it can be classified as a state under Article 12. This principle was encapsulated in a set of tests, each focusing on different aspect of the institution relationship with the government. So यहाँ पे क्या हुआ, सुप्रीम कोर्ट ने बोला, जो रेसो डिसेंडेंडी इस केस में दी अजय हासिया वर्सेस मुसीद में, कि जो फंक्शनैलिटी है, जो स्ट्रक्चर है और जो फाइनेंशियली एक्टिंग है, वो अगर एजेंसी लाइक एज ए इंस्ट्रूमेंटलिटी अगर वो कर रही है, सो उसको वी कैन डिसाइड एज ए स्टेट. Obiter dicta in the Ajay Hasia case. While in the main focus on the court judgment was on the interpretation of the Article 12, the judge also offered observation on the broader implication of the case. They emphasized the importance of the constitutional mandate and the upholding of the fundamental right by the institution performing public function or wielding proper public power. The court stated it that it would be contrary to the basic tenet of the constitution to allow a body performing essential government functions to evade constitutional responsibilities simplify by adopting a different legal form. This observation, while not directing link with the decision, provide an insightful commentary on the ethos of the Constitution and the principle of justice, equity, and the rule of law that is embodies. Okay, so यहाँ पे सुप्रीम कोर्ट ने कहा कि जो बेसिक टेनेंट है, जो लाइक जो फॉर्म है, उसको सुप्रीम कोर्ट ने ऑब्जर्व किया और डायरेक्टली डिसीजन दिया कि एक कमेंट्री दी कि जो इथोस है वो जस्टिस, इक्विटी एंड लाइक एंड द रूल ऑफ द लॉ के ऊपर डिपेंड करता है. अजय हास्य वर्सेस खालिद मुसीद में जो सुप्रीम कोर्ट की फाइंडिंग थी, दैट इज दिस: द कॉन्सेप्ट दैट द फंडामेंटल स्ट्रक्चर and financial relationship of a body with the government determine its status as a state rather than its formal standing is a settled legal principle. Moreover, the decision confirmed that such bodies classified as a state under Article 12 are obligated to uphold fundamental rights, extending constitutional protection to citizens against these bodies. The case has not been overruled or diluted by the subsequent judicial decision, and the principle articulated therein continue to hold sway. The precedent set by the Ajay Hasia case remain an authoritative interpretation of Article 12 as it roundly rely upon the constitutional adjudication. As such, as the judgment's relevance and impact continue to be felt in the Indian legal system. The Supreme Court, in its judgment, emphasizes the importance of the principle of natural justice, which include the right to be heard and the right to be fair and impartial decision-making process. The court held that the denial of the admission without providing the affected students with an opportunity to be heard violate these fundamental principles of bodies. So P.K. Ramcharan Iyer versus Union of India, ICR as a state in this case. This case may be, I mean, and now we are going to discuss the Tekram versus Union of India. In this judgment, Supreme Court referred to the judgment of Sabit Tewri versus Union of India, and the Supreme Court held that the Council of Scientific and Institutional Research, Industrial Research, is an authority within the meaning of Article 12 of the Constitution. Based on the analysis and the precedent, the court hold that the institution of the constitutional and parliamentary studies is not authority within the meaning of Article 12 of the Constitution. The writ petition fail and is dismissed. ओके, सो टेकराम वर्सेस यूनियन ऑफ इंडिया में सुप्रीम कोर्ट ने रेफर किया साबित तेवरी वर्सेस यूनियन ऑफ इंडिया को, जिसमें सुप्रीम कोर्ट ने हेल्ड किया था कि जो काउंसिल ऑफ साइंटिफिक एंड इंडस्ट्रियल रिसर्च है वो article is an authority within the meaning of Article 12 of the Constitution. And based of the analysis and precedent behalf of the case of Sabit Tewri versus Union of India, Supreme Court held that the constitutional parliamentary studies is not the authority within the meaning of Article 12 of the Constitution, and इसकी जो writ petition थी वो dismiss कर दी गई. So R.D. Shetty versus Airport Authority of India, इस केस में क्या हुआ था? इस केस में मैं first of all I'll let you know the issues. So first issue इस केस में था whether the International Airport Authority is state under Article 12 of the Constitution of India, कि जो International Airport Authority है क्या वो state के अंडर में I mean that is going to be state under Article 12. सेकंड जो इसमें इशू था वो था वेदर द टेंडर कंफर्म बाय द रिस्पोंडेंट इज द कॉन्स्टिट्यूशनली वैलिड, और जो टेंडर कंफर्म किया गया था रिस्पोंडेंट के द्वारा क्या वो कॉन्स्टिट्यूशनली वैलिड है. So the tender granted by the fourth respondent is not valid as he did not fulfill the condition mentioned under the tender invitation. So इसमें फर्स्ट चीज जो जजमेंट में बोली गई थी कि जो टेंडर है जो ग्रांट किया गया था फोर रिस्पोंडेंट के द्वारा, दैट इज नॉट अ वैलिड कॉन्ट्रैक्ट एज ही इज नॉट कंप्लाई विद द कंडीशंस जो इन्विटेशन में दी गई थी. इट वाज मैंडेटरी फॉर द एयरपोर्ट अथॉरिटी टू अबाइड बाय द इन्विटेशन. Had he known that the compulsory adherence to the rules was not mandatory, he would have given his tender offer. The arbitrary procedure followed by the authorities violate of the Article 14 of the Constitution. So this is all about it. Okay. So if you like the video, please like. Thank you for the watching. Like, comment, share, and subscribe to the channel. More videos are coming related to the fundamental rights. So thank you.